I'd like to reserve 5 minutes of my argument for rebuttal. I need to start out by pointing out that I think the state has made an error in their brief by arguing that the disorderly conduct of Ms. Every stemmed in part from her conduct at the Nama restaurant. The proof at trial and the argument to the jury was that one crime occurred at Nama, which was an assault by offensive touching, and that the other crime occurred after Ms. Every had left the restaurant and was found walking on the street by the police, where she was accused of disorderly conduct by making unreasonable noise that prevented others from carrying on lawful activities.
Well, that was a question I had. I mean, honestly, based on my understanding of the facts, that could have applied to either incident. So are you saying it was clear at trial that was only argued that was the incident on the street where I think there were some workers that yelled back at her, et cetera?
I believe it's clear from the record. It was clearer to me being there that that's what the issues were at trial, but I think even from cold review of the written transcript of the trial that's apparent. I mean, that was the argument I believe the state made at the end, and it was the focus of the way the proof was presented in the court.
Because it clearly could have applied for the behavior at the restaurant as well. It certainly appeared.
The argument was certainly made, but that argument was made, in my opinion, for the first time on appeal. But even taking that argument as that she was engaged in disorderly conduct by making unreasonable noise in two separate locations, the proof is deficient on that because there is not proof that in either instance it prevented others from carrying on lawful activities. And I think the key words there are preventing. And also others. The proof on the street was that one person called out something. It wasn't quite clear exactly what, but it was like chill it or settle down or something of that nature. Those were men unloading a truck. There was no proof of who they were, of what they were unloading, of the nature of the unloading they were doing, or that they even were interrupted, much less prevented.
What was the proof that came in at trial on that?
It was just that one of the people made a comment that she needed to chill out or shut up or calm down.
Yeah, who testified to that? Was it the
Officer Coffey, primarily, one of the police officers. Officer Coffey. And he was asked, did you find out who it was? Did you find out what they were doing? Did you find out whether they were interrupted or paused or whatever? And he couldn't really answer those things. And at the restaurant, she made noise, and it may have been unreasonable noise, but there was no real proof that others were actually prevented from carrying on lawful activities.
Well, wasn't there proof that some of them had to stop what they were doing in the back and come out and try to help address to get her out of the restaurant? I mean, that to me is spot on with that charge. Again, I haven't dove into the record to see if that's what was actually argued.
Well, there was testimony that she initially argued with a person who was working near the front of the restaurant, that person went and got a manager to come and talk with her, and then two gentlemen also got involved. But they voluntarily got involved. It was not that the noise
They were asked to get involved because the people working there needed their help, so they had to stop what they were doing to come out and try to help address the issue, didn't they?
I think the female manager was asked to get involved by the front-end employee who was sweeping the floor when she came in, but the two gentlemen heard the commotion and got involved on their own, essentially, I believe is the way the proof came in. It's certainly the way it's argued in the state's brief. Not that they were called upon, but that they just chose to involve themselves.
Do they have to be called upon? I mean, if it's just so disruptive that they stop what they're doing and are interrupted from what they're doing to come address the situation, isn't that sufficient under the statute?
I don't think so, because the statute requires the noise to prevent the carrying on of lawful activities.
No, but if a person is so disturbed or interrupted in their course of whatever they're doing that they feel that they have to stop and either go offer assistance or see what's going on, I mean, isn't that the interruption? where they stop what they were doing?
In my opinion, it is not, because it's not, the statute doesn't say they're interrupted. It says they're prevented. And I think that word is an important word. I don't think we can say interrupting somebody from doing something necessarily prevents them from doing something. And the other cases that I've
Who
seen.
decides whether they're prevented or not? I mean, I feel like that's my personal choice. If somebody is so disruptive that I make a decision that I have to stop. And I mean, is that not just what a jury would consider, whether that was reasonable for someone to feel like they had to stop what they were doing because of the disruption? I mean, the way you're arguing it, I don't know how it could ever, be convicted under the statute.
In my conception, the statute applies to situations where someone makes so much noise that they're disrupting a lawful activity that's going on like a service or a meeting or a procession or something of that nature. There are disorderly conduct cases dealing with that scenario where someone can't complete a prayer service or a funeral or something of that nature. But this is a situation where, and the noise is done with the intention of disrupting whatever that activity is, and does prevent it. Here, she was having a customer service complaint with people at the front of the restaurant, and other people chose to become involved, and none of them testified that we were prevented from carrying on lawful activities. They talked about being interrupted, and one of the gentlemen left his drink he was having to come and ended up calling 911 and helped, describe her to the police. The other one just said he heard a commotion and came forward to back up his manager. And to me, they got focused on her, but that is not proof that they were prevented from completing whatever they were doing, in my respectful opinion. But I'll leave that. I don't want to argue too much over a fact like that. I think the main focus of this brief, really is problems. Well, I don't know. I shouldn't say that, because all these issues, it was hard to decide which ones were the most important to me. I think the problems with the indictment, though, are important issues that need to be mentioned. And that basically is that in count 1, where it describes assault, it omits the reasonable person standard that's in the statute and doesn't really replace it with anything. It talks about conduct that is carried out in an offensive or extremely provocative manner, as opposed to conduct which a reasonable person would find to be extremely offensive or provocative. And so it leaves out a factual element of the offense of assault. And with regard to the disorderly conduct count, it omits any reference whatsoever to the culpable mental state. It has a reference to the disorderly conduct statute itself, but the culpable mental state is not found in the subdivision of that statute that the indictment was drawn up under. You have to look at the general culpability statute to see that, a different statute that's not referenced in the indictment, and then you have to determine which culpable mental state would apply, and that was left out. And the state has cited the same authorities we did regarding the omission of the culpable mental state from an indictment, which basically holds that it's not required to be expressly included if, A, it's got a statutory reference to where you can see what it is, or B, if it can be logically inferred from the contents of the indictment, or a third one, which also would not apply in this case. So I think the omission of that from the disorderly conduct statute makes that indictment void for failing to allege all the factual elements of the offense. And in the assault count, the same thing. When they leave out that it has to be something that a reasonable person would find especially offensive or provocative, they've left out an essential factual element of the case. And of course, the court's jury instructions didn't track the indictment language. It did track the statutory language, and you can compare the way the court charged the jury to the facts that's alleged in the indictment, and the indictment did not allege the same facts that the court told the jury they would have to find in order to convict the defendant beyond a reasonable doubt.
But truly, I mean, isn't the purpose of the indictment to put the defendant on notice of what they're being charged with? And even though the indictment doesn't track exactly, I don't disagree with you there, what the statute is, it generally says what the charge is, and it cites to the statute for each of the counts. So
That is true.
How can you get around that?
Well, you know, I'm perplexed by that myself, because there's one collection of cases that basically says the indictment must plead every essential factual element, and if it doesn't, it's void. But then there are other cases which say an indictment is sufficient if it simply puts the defendant on notice of what they're charged with in terms of referencing the statute generally, maybe not by specifically alleging all the facts, and it's sufficient so the court can enter the judgment that it needs to enter and to protect them from double jeopardy. So to me, those cases haven't quite bridged the gap between the two of them. If you've got one that says an indictment's void if it doesn't allege every essential factual element, but other cases that say an indictment is sufficient if it just puts them on notice of the statute under which the charge is brought, to me that's not consistent. Those things don't exactly line up, and I think
If you're representing this defendant, can you honestly, with a straight face, argue that you would not know what the defendant was charged with and how to prepare a defense?
That's not really what I'm arguing. No, I don't think I could argue that with a straight face, and that is not intended to be my argument. My argument really is that there are cases in Tennessee, and I don't think they've been reversed, and I think we've cited them, that say you have to allege each essential factual element. And that is the collection of law we rely on. The state is relying on another collection of law that says you can get by with less than that. And I don't think those have been fully reconciled at this point. So that is the reason we presented those issues.
So you're saying that a reasonable that the state has to prove that the alleged victim, the person that was contacted, is a reasonable person. They have to prove that as an element.
No, they have to. I think they have to prove that a reasonable person, not necessarily the alleged victim, but
Well, but if it's not a reasonable person, then it's not there's no crime, right?
right,
So
it has to be
based on what
something a
you're
reasonable. Yes.
So you're saying the burden of proof is on the state as an element to prove that the person that was contacted in whatever way is a reasonable person.
No, that is not what I'm trying to
You
argue.
said it's an element, and if it's an element, the state has to prove it.
Yeah, but it's not what a reasonable. The statute doesn't say what a reasonable person in the victim's position would think. It
Well, then what are we
says
talking about if it's not a reasonable person?
anyone
In
who
the
knows
victim's
about it,
position.
a person, any observer or anyone informed of the facts is the one who a hypothetical reasonable person is the one who decides whether the conduct would be extremely offensive or provocative.
I'm having difficulty understanding your concept, but that's fine. I don't want to belabor the point.
Well, I want you to understand it because I don't expect to win unless I can at least
Well,
be
you said
understood.
it's an element.
I believe that the
And so a
reason,
person so the state has to prove what a reasonable person is, rather than not that the victim is a reasonable person, but what a reasonable person is.
they have to prove what a reasonable person would perceive or regard.
So how do you prove that? Isn't the whole world, wouldn't you consider the whole world to be a reasonable person? And then it's in the jury's position as to their determination as to what a reasonable person is. It's not up to the state. I mean, do I have to bring in an expert to prove what a reasonable person is?
I know.
If I were the prosecutor, would I have to do that?
I would not think so, but I think
But you're saying that somebody has to explain what a reasonable person is to the jury because it's an element.
Well, no, I'm saying the jury has to be able to conclude that a reasonable person would have regarded that conduct as extremely offensive or provocative, and they can.
You keep saying element. It's an element because you said it's an element, right?
I believe it
And
is.
elements are things that the state has to prove, right?
Correct.
And
But
the
how do
jury
you-
was charged with that.
They were.
Okay.
So they did what you're arguing that wasn't done or wasn't, I guess, charged in the indictment, the jury actually did consider that.
They
And
got
they
it.
had the correct charge, so how can there be any error or prejudice there?
It's because the indictment did not allege those elements on the front end. In my conception, the indictment and the jury charge have to correspond to each other. If the indictment doesn't allege something that is an element of fact that has to be proven, then it has omitted that. And if it's omitted, the indictment itself is not valid, is the argument. And I've only got 20-something seconds left, so I'll reserve my remaining time.
I
Thank you.
appreciate your clarifying that for me.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments and the defendant's convictions because the indictments were sufficient to put the defendant on notice of the crimes of which he was charged, because the proof overwhelmingly established guilt, and because the trial court properly denied the defendant's request for an instruction on self-defense. Briefly, I'd like to get into the factual background, provide some context as to what we're talking about and what happened. So on October 5th, 2021, the defendant committed assault and disorderly conduct. She entered a restaurant called Nama. It's a local restaurant in downtown Knoxville after it had already been closed, but the doors had not been locked yet. She apparently told them that she had been trying to place a to-go order, and when informed that, we're closed, we cut off to-go orders beforehand, she became, quote, really aggravated. She was asked to leave and then began to cause even more of a commotion. In fact, to your point, Judge Ayers, she caused such a commotion that a chef who was working in the back of the restaurant felt compelled to stop what he was doing and come out to see what was going on. When he realized that the defendant was causing this commotion, he attempted to sort of usher her out of the restaurant, but he made very clear that he always stayed an arm's reach away from her and that he never placed a hand on her.
Testified contrary to that, didn't she?
She testified contrary to that. The jury was entitled to accredit him and discredit her. So what the proof showed was that as he was ushering her down, trying to usher her out of the restaurant, she made a two-handed shove and pushed him into the hostess table before leaving. She then left the restaurant. She started shouting at some bystanders outside. She continued walking around downtown, shouting certain expletives and things about police officers. She was shouting so loud that she actually caused the workers who were unloading a truck to stop and try and calm her down before ultimately.
And so what is the proof in the record on that? And kind of a multi-part question, that disorderly conduct in the second count, what conduct was, what of her conduct was alleged to violate that? Is it the restaurant conduct or the conduct on the street?
So I think either, Your Honor. If we're talking in terms of sufficiency, either. I think that my friend on the other side is correct. If the record will speak more accurately, but I think the state's theory was when she was shouting outside, causing disturbances to bystanders to these individuals loading truck. I can cite to it's volume 3, pages 192 to 95, and there's a video exhibit 5.
What will the video show us when we look at that?
That is a better. It's a good question, Your Honor. I think that they ultimately just sort of stop their work and verbally talk to the defendant and tell her to calm down.
So we're going to see on the video workers stopping and yelling at her.
Your Honor, the record will be more accurate than my recollection, so I'll defer to that. But ultimately, there are a number of ways that the defendant committed disorderly conduct. It was sort of a continuing act. And the jury, so the state had a theory and presented that, but the jury wasn't bound by that. And the indictment covered the entire scope of her activity. And certainly, if we're getting to sufficiency of the evidence, which the defendant challenges, the proof overwhelmingly established guilt for both. Turning to disorderly conduct, the proof clearly showed that she was so boisterous and loud and caused such a disturbance at the restaurant that she caused individuals in the back to stop what they were doing, particularly the chef who was assaulted, and come and see what was going on. There's also proof that, again, she was outside, she was yelling at bystanders, causing them to stop. And a rational jury could find that stopped them from at least temporarily to see what was going on. And then again, caused these workers to at least stop for long enough to tell her to calm down. And finally, there was a police officer who heard her disruptive and noisiness, caused him to go out of his way and detain her.
I mean, we don't see a lot of disorderly conduct cases here. So, I mean, I'm not real familiar, and I didn't have that many as a trial judge. So, I mean, what do the cases say as far as, does it have to be, as appellant has argued, disrupting some kind of public, ongoing, ceremony or something? I don't read that into the statute, but I'm just curious as to what's out there to tell us what really is disorderly conduct.
I also
I've got the statute, but
Yes,
it
Judge.
doesn't say. Literally, it just says, a person also violates this section who makes unreasonable noise that prevents others from carrying on lawful activities. That's very broad.
It's certainly broad, and like you, Judge Ayers, I don't read anything into it. I think some of the cases, especially the cases that have come up on appeal, tend to deal with other situations, but that doesn't mean that the statute is somehow narrowed based on those particular cases. My friend on the other side today talks about how some cases talk about an intention of disrupting some sort of conduct or some intention, but part of his complaint here is that that's not part of the statute. There is no mens rea. And so, pursuant to a different statute, as long as the defendant acts recklessly, that's sufficient. And certainly the jury could find here that the defendant acted recklessly in this entire course of conduct, at the restaurant, outside of the restaurant, walking through downtown, and then interacting with the police officer. And so any rational trier of fact could easily conclude that she had committed disorderly conduct during that course of action. Similarly, a rational juror could find that the defendant had committed assault by causing offensive contact. To your question, Judge Montgomery, who decides what a reasonable person is? That's the jury. When we're looking at sufficiency, could a rational juror reasonably find that this contact was offensive? And they could. The defendant did a physical two-handed shove into this individual who was simply trying to get her out of the restaurant. She forced him to fall into a hostess stand.
Shouldn't the indictment have included that language?
It did, respectfully, Your Honor. So it omitted the reasonable person standard, but it certainly said that the defendant, quote, did unlawfully and knowingly cause physical contact with Juan Guzman, the victim, in an extremely offensive and provocative manner, and specifically cited to the statute charging a simple assault. The state's position is that that's certainly sufficient. There's no requirement to have the exact language of any particular statute. Really, my friend on the other side suggests that there might be a split of authority. To be clear, the controlling law in this area is State v. Hill. And what Hill says is for an indictment to be valid, it has to do three things. It has to enable the accused to know the accusation to which the answer is required. It has to furnish the court an adequate basis for the entry of a proper judgment. And it has to protect the accused from double jeopardy. The indictments here do all three of those things. The state's position is that that's sufficient. Whether the complaint is that it doesn't include language saying reasonable person or it doesn't explicitly do the culpable mental state, the indictments are valid. And regarding the culpable mental state, this case is directly on point with State v. Harvey. This court has addressed that situation before and said that it can very easily and logically be inferred what the culpable mental state is given the statutory scheme. That's sufficient. I don't want to take any more of this court's time. If this court doesn't have questions on the self-defense instruction, seems that the defendant has relied on his brief with that, and so the state will rely on its brief as well. If there are no further questions, we ask that this court affirm the judgments. Thank you.
Thank you. Counsel?
Briefly, with regard to self-defense, I'll just say that I think the evidence did create a sufficient question about that. It should have been charged to the jury. The theory that the court had was that since she had been told to leave, she was not in a place where she was entitled to be. But the instructions to leave were all conditional. up until after she had shoved Mr. Guzman, when he said, okay, now you really need to leave. Before that, they were
Because
saying.
he didn't mean it the first time?
Well, before that, they were saying, if you don't calm down, we're going to have to call the police and things of that nature. So they weren't just saying, leave, leave, leave. They were saying, if this, then that, and it was not an order to leave. Plus, there was a dispute about whether the restaurant was even still open or not. Now, I admit, I guess if I'm in a restaurant and the owner comes and tells me to leave, it doesn't matter if it's open. But if they come and say, if you don't do something, then you're going to have to leave, then that's just not an unequivocal instruction. I think the court essentially found that she had probably committed a crime of criminal trespassing by not leaving, and wouldn't instruct the jury on that basis. And that was, in my opinion, a jury question. And I want to touch briefly on the disorderly conduct, on the offensive touching part of the assault charge. The jury had a question, and it's an exhibit in the record, which is, can you define extremely offensive or provocative? And at the time, none of us, neither me nor the state nor the court, realized there was a case that actually talked about that, about what that meant. And instead of finding that, since none of us remembered it, the court simply told the jury, you're going to have to rely on the instructions I've already given you, in effect. And we think that in response to that question, the jury should have been provided a more substantive answer, since that answer does exist in our law. And it sort of illustrates the fact, if that's their question, whether this rises to the level of extremely offensive or provocative.
But none of that was raised at the time? No objection or anything on the record to preserve that issue?
Not much. None of us thought of the case that I've cited in my brief, so it didn't get charged to the jury in the supplemental instruction. They were just referred back to what they'd already had. So they had a question, and there was an answer in the body of our state's jurisprudence, but they were not given that answer. And maybe it was waived because the defendant didn't bring it up. But I think everyone there all had a duty to try to do that. We all fell down on that, so they didn't have the benefit of that. I'm as responsible for that as anyone else, maybe more so.
Thank you, counsel.
Thank you.
Good. Do you want to check on Francesca? See if she needs a break?
You need a break? You need one? All right, we're going to go straight through. Call the fifth case, please.